In this month's edition of the Video Advocate, we're going to start talking about fair housing. Ultimately, we will be doing a series of videos on various aspects of fair housing. This month, we're going to start with what we call source of income discrimination. Fair housing, as you know, is a pretty hot topic in general, and the issue of source of income discrimination has recently been brought to our attention by a number of people who are interested in learning a little bit more about the nuances of that topic. In this segment, we're going to try to give you a little bit of clarity around those nuances so that you can make the right choices and protect yourself from any sort of claim that you're not abiding by current fair housing laws. Many of you may be familiar with the most prolific housing subsidy program, that is the Section 8 program funded at a federal level, more recently referred to as the Housing Choice Voucher Program. While that program at a federal level is considered a voluntary program, here in Connecticut, under the concept of source of income discrimination, Section 8 is in fact a mandatory program, as are any other programs providing some sort of outside subsidy to a tenant who is applying for or living in a unit that you manage or own. Under Connecticut law, it is illegal to discriminate on the basis of someone's source of income. For example, the Section 8 program, or another very common one that you may have encountered is the Security Deposit Guarantee Program. What it ultimately means is you cannot discriminate against someone who receives a subsidy under one of these programs or who comes to you with a security deposit guarantee as an alternative to your otherwise anticipated cash security deposit. And although someone may receive a subsidy and be protected from discrimination based on that subsidy, that doesn't mean they get any special privileges associated with their becoming tenants in your property. For example, they must complete the exact same screening that you give to everyone else. That includes appropriate credit and appropriate criminal background if those are things which you screen all of your applicants for. Nor does it mean they get a special lease. You should be using the same lease you use for all of your market tenants for anybody who receives any sort of source of income assistance to pay their rent. One of the main differences you're going to find with an applicant who receives a subsidy is that the subsidy provider will anticipate and expect you as the landlord to sign a contract with them, verifying a variety of different things. It is highly recommended that before you sign that contract, you review it with your landlord attorney to make sure you're in complete understanding of the program that you're getting signed up for. It is critically important that you know all the aspects of that relationship as you go forward with the program that your tenant is bringing to your property. I hope this was helpful in explaining what source of income discrimination is and what you can and can't expect. If you have any questions, please feel free to reach out to us or to reach out to your landlord attorney to discuss those questions in advance. Again, I'm Robert Chesson with the Landlord Law Firm. Thanks for joining us for this month's edition of the Landlord Law Firm's Video Advocate.